And with the passing of Ruth Bader Ginsburg, should the president and the Senate look to fill her seat before the November election, or at least before a new president takes the oath of office in January, no matter who that happens to be? I thought we'd talk about it with John Malcolm, because I'm not a lawyer, but he's vice president of the Institute for Constitutional Government and director of the Meese Center for Legal and Judicial Studies. John, welcome back.
Good to be with you, Lars.
So thank you for that. Tell me this, first of all, the objections the Democrats have raised. Near as I can understand the history, 29 times a president in the same situation, election year, the president's in office, he nominates, and in that case, the Senate takes up the nomination. They don't all get confirmed, but most of them do. Is there any real reason to hold off, as Joe Biden and others have said, until after the election?
Well, there's certainly no impediment that would prevent them from moving ahead with the nominee. I mean, so the process: the president nominates, and the Senate gives advice and consent, or they can withhold that advice and consent, which is, of course, what they did in 2016. It's a different situation. Presidents and the Senate are both in the hands of the Republicans at the moment. I think that there are some Republicans and Democrats who are both eating the words that they said in 2016. But each one of these nominations is different. And look, vacancies don't come along very often. There are only 9 justices up there, and so personally, I'm in favor of filling it. But that's because I'm a conservative, and the Republicans happen to control the Senate and the presidency. It's in part about principle, it's in part about history, and in part it's about power.
Now, I know this is a legal concept, but there's a thing, I'm not a lawyer, as I said, they're called stare decisis, where we kind of like the courts to be consistent. And in fact, I see that the Supreme Court certainly operates by it. They say if we decide something, we're not going to change our decision, at least not anytime soon, or at least until circumstances have changed. At the state level, I've seen courts that say, well, if we didn't give the death penalty to this guy for his horrible crimes, then when other people come along or that are up for the death penalty, we may also say we want consistency so that we don't have inconsistent results. Is there a single time in American history where the president and the Senate have been of the same party and the president has failed to make a nomination in this circumstance?
I don't know that they failed to make a nomination. There is precedent for nominations being made where they failed to get through.
Correct.
So Lyndon Johnson, I remember, at a time in which the Senate was controlled by Democrats, nominated Abe Fortas to be Chief Justice. He ended up having ethical issues, and he ended up withdrawing his name. And by the time that happened, it was too late for anything else to be done. And then, Nixon won and nominated Warren Burger, and the Republicans took control of the Senate. But look, this is a political sphere. The Senate does not have to be governed by precedent. They have to be governed by their own rules unless they change them, and they have to be governed by the Constitution. That is a very different consideration from courts' adherence to precedent, which you talked about. So stare decisis means basically once you decide an issue, you want the public to have a certain consistency and understanding of what the law is so they can govern their affairs. It doesn't mean that you can't overturn precedent. If that weren't the case, then we would still have Plessy versus Ferguson as the law of the land, separate but equal, not Brown versus Board of Education. But you shouldn't do it willy-nilly. There should be a good reason. Either it was profoundly wrong when decided, or it has really not stood the test of time. And you should approach overturning precedent carefully. But they do it. The Supreme Court does overturn precedent, but precedent means something very different in a legal sphere than it does in a political sphere.
And usually, as you said, they have to have an explanation. The reason we're doing it a different way this time is because something is different. Other than the fact that apparently a lot of people on the left and even some people on the right don't like Donald Trump. Other than that, is anything different than those 29 other times that 22 of America's 44 presidents have made nominations?
No. I mean, look, the president serves for up until the time, January 20th, for either at the end of their second term or if they are defeated. And up until that time, the president can nominate, and the Senate can decide whether to take up that nomination or not. They may couch it in terms of principle and point to this distinction or that distinction, but they really get to set the rules, and no two nominations are the same.
Okay, I'm talking to John Malcolm from the Meese Center. So what about this? Given that the court starts its new term on the first Monday in October, famously, or I guess that's the way you say it, we've always talked about first Monday in October. Is there an important legal reason, John, that the court be a complete court, and especially as we head up to an election in which Joe Biden, I think, announced in August that he was planning to contest the results of the election, and he was hiring lawyers to do it. I think he's already decided he's likely to lose, and he wants to challenge it, and the election hasn't even happened yet. But given that, should we have a 9-member court, especially for the election, but in general because the court begins a new session rather than waiting until, I don't know, if Biden won and he came into office, when's the soonest I guess he could make a nomination on January 21st, but then we'd be looking at the new justice perhaps joining the court 30, 40, 50 days into the new year. And the court's term ends in June.
So the answer to your two questions are: I don't think it's that significant to have a 9th justice when the court begins its sessions on October 9th, or I guess in October 3rd, whatever. The first Monday in October is potentially quite important in terms of having a 9th justice up there if we end up having another Bush v. Gore situation where the election is being decided by the Supreme Court. It would be a disaster if this went up to the court and it was split 4-4. The reason I say that about the court on the 9th is that the court has operated with 8 justices for significant periods of time before, and what that ends up happening is you end up having rulings that can be 8-0, all the way to 5-3. If you end up having a 4-4 tie, the court has two options. Either by rule, it just means the lower court opinion is affirmed, but it doesn't have any precedential value. Or if it's important enough, the court can wait until it gets a 9th justice and then set the case for re-argument. So I think the court can get by in its run-of-the-mill cases with 8 justices, certainly for a period of time. But if there's an election dispute and it gets to the Supreme Court, might be very critical to have that 9th justice.
Well, John, 6 weeks out or so, are you anticipating that either way there's going to be that the election will be contested? I
think the way this election is shaping up, particularly with all of these mail-in ballots and so we'll be talking about authorized signatures and when ballots were postmarked instead of dimpled and hanging chads. I think depending on how close this election is, there will be an awful lot of lawsuits filed, and it could be extremely messy and very destructive for the country.
All right. In the last 30 seconds, any thoughts on the Democrats' threats to either impeach the president again or pack the court if Trump chooses another justice?
I think if Trump chooses another justice and the Democrats take control, keep the House, take control of the Senate, and win the presidency, they will pack the court. And even if he doesn't get his nominee through anyway, they might pack the court. I think the idea of the House impeaching either the president or Bill Barr in order to put off a nomination hearing is very far-fetched, and I don't think it would happen. But, desperate times for the Democrats may call for desperate measures, and they clearly have not taken that arrow in their quiver, to quote Nancy Pelosi, off the table.
I don't often credit Rahm Emanuel for being right, but he even came out and said these are ridiculous ideas that are some of the ideas that start to tear the country about. John, thank you very much. That's John Malcolm at the Meese Center for Legal and Judicial Studies.